Morning, Mr. Secretary.
Recording in progress.
Good morning to everybody. Sorry for the late login. I think I might have erased the login details by mistake. So as I was searching for them, I could not find them. My apologies for being late. You are all welcome to this meeting. Can we start with the NPA amendment bill?
Okay. Good morning.
Honorable Jole?
My apology for this. I'm trying to get to another gadget. I will be traveling, but I'm looking.
Honorable Swart?
Morning, Chair. I also want to tender an apology. I'll be going to the Chief Whip's Forum from 10 o'clock on. Thank you, Chair.
Thank you very much. Let's quickly deal with the NA amendment bill. Honorable Horn?
Yeah, thanks. Good morning, Chair, and good morning to all colleagues and others on the platform. Chair, yes, unfortunately, I will also be unavailable from about 1:45, 1 o'clock onwards when I made my arrangement. I was unfortunately not aware that this meeting was to be scheduled to go on until 2 o'clock. So please, for that part of the meeting, please note my apology.
Thank you. Well, I don't think it's likely to reach 1 o'clock. I don't think so. But if that materializes, then we will note your apology. Committee Secretary, can you flight the A list? Here is the A list. Can I now put the bill as a whole? Any seconder for the NPA amendment bill to be adopted? Any mover?
Chair,
Honorable Maseko Jele?
I move for the adoption of this.
Thank you very much. Thank you very much. Any seconder?
Honorable Neodruchen, seconds, Chair.
Honorable New seconds. I'm sorry about that. Any objections?
Right.
EFF, we object to the bill.
The
Chair.
EFF objects to the bill. Honorable Swart.
ACDP reserves its position, Chair, at this stage. Thank you.
The ACDP reserve its position. Honorable Breitenbach.
Morning, Chair. Good morning, everybody. We reserve our position.
The Democratic Alliance reserves its position. The bill is agreed to with the reservations of the Democratic Alliance and the ACDP. Can we go through the report? A report of the Portfolio Committee on Justice and Correctional Services on the National Prosecuting Authority Amendment Bill B29 of 2023, dated 22nd November 2023. Are there any corrections on page 1? Sorry, can you go down? Okay, there are no corrections on page 1. Page 2. Is there a mover for the adoption of the report?
Chair, I move that the report be adopted.
Honorable Mwala moves. Any seconder?
Honorable Neodruchen, seconds, Chair.
Honorable Neodruchen seconds. Any objections?
EFF objects. Chairperson, apology for not raising my hand, Chairperson. I'm still trying to find where I can. But yes, EFF objects.
EFF objects. The report is agreed to. Thank you very much. Let's go to the next item. Honorable Deputy Minister, sorry, you're welcome.
Good morning, Chair, and good morning, members. Just to say that I'll be in the NCOP Select Committee meeting to deal with the Judicial Matters Amendment Bill, but we'll come back for the briefing on the hate crimes, hate speech amendments.
Okay. No, that's fine, Deputy Minister.
Just tell the Deputy Minister we have passed apologies. Passed it a long time ago.
No, thank you very much. No, thank you very much, Deputy Minister.
In the interests of organizational unity, I will keep quiet.
No, thank you very much. No, you are excused, Deputy Minister. Who is a parliamentary liaison officer? Ms. Johnson. Is Ms. Johnson present so that if we finish earlier, we can alert you? I think he's already gone.
I see Ms. Johnson's, is Carol's iPhone on the platform, Chair.
Yes, we are not sure whether it's Carol, the advisor to the minister, or Carol Johnson. No, but I think when we are done, we will contact the Deputy Minister. Let's proceed. Let's deal with the issue of the impeachment of judges. 2 judges, Judge President Hlophe and Judge Mutata. Before I invite Dr. Lutz, I think it will be important to start with the one of Judge Mutata. If we can just do a quick recap, we know that after this matter was referred to us, we wrote to Judge Mutata to ask him whether he has any extenuating circumstances that we might need to consider as a committee before we make a recommendation to the House. He came back to us to ask for a postponement, in fact, that we grant him an extension, until the 30th of November, in addition to the 1 month that we had given him. We did not agree to the 30th of November, but we gave him and Judge Klope 2 extra weeks. And then Judge Mutata responded to us, and in his response, he raised 2 issues. One was the issue of jurisdiction, and secondly, it was an issue of double jeopardy. On the issue of jurisdiction, his contention was that the JSC has not referred the matter to the Speaker or to the Speaker of the National Assembly. They just took the decision of the Supreme Court of Appeal and sent that letter to the Speaker. So as a result, the National Assembly will not have jurisdiction. Well, we received an extensive briefing from Dr. Lutz on that issue, even application of the rules of interpretation. But we thought that to avoid a lengthy court case on a procedural point, that we must write to the JSC to get clarity from them. One, on the issue of double jeopardy, because his contention is that the JSC found him guilty on misconduct, and he was fined 1.1 million, which he paid. If we proceed with this process, so it will be jeopardy on his side. So we raised the 2 issues with the Judicial Services Commission. The Judicial Services Commission, the Chief Justice convened a small JSC, that is the JSC without members of Parliament. Anything that has to deal with the impeachment of judges, the JSC sits as a small JSC without members of the National Assembly and NCOP. That was convened last week on Friday, on the 17th, and the resolution was adopted, referred to the Speaker, and the Speaker has referred that resolution to us, and members have got in possession of that referral from the JSC, and the Speaker has referred that matter to us, and they've also undertaken that they will interact with Judge Mutata on the 1.1 million he has paid, because that decision of finding him guilty of misconduct was eventually overturned by the Supreme Court of Appeal and replaced with the verdict of gross misconduct, and that is why we are here. I thought that I must give that background, that we have responded to the 2 issues that Judge Mutata raised, and there were no additional extenuating circumstances that he raised. Dr. Lutz, do you want to say something on this matter before I open for members?
Thank you, Chair. No, I think you covered it perfectly, Chair. You're going to put me out of a job. You said it all. Thanks, Chair.
You know, I was taught by the good Dr. Lutz. Thank you very much, members. That is the background. So the first point we're dealing with is the impeachment of Judge Mutata. Honorable Janji, followed by Honorable Ngola.
Good morning, Chair, and good morning to colleagues and everybody on the platform. Thank you, Chair, for that background that you have just outlined based on the roadmap that this committee, from the very beginning when these matters came in front of us, that we agreed to, that this is how we're going to run this process. We determined and demarcated key milestones, the matters, the dates you're referring to, and deadlines and requests would have been responding to that framework and process that we agreed to. In fact, today, even though you have not said it as part of that framework, it's Deliberations Day, based on everything else that we would have outlined. And thank you for summarizing what we ourselves would have followed, received those letters and stayed close to them. Just on Judge Mutata, I think that the clarity that in your signature that you sought from the JSC was very critical, so that there are no gaps, there's no confusion about that. And I'm happy that the response came back on time within our framework, which we insisted to the chair of the JSC, the Chief Justice in this regard, that they would have confirmed. What they have confirmed is what we ourselves as this committee would have believed to be the correct understanding. We were very clear from the very beginning. I would not go into what we raised before. We were clear that whatever the JSC did before of not following the Constitution, trying to cut, to do shortcuts and create their own threshold of a misconduct when the issues about the gross misconduct, it's something that we're going to talk about in relation to especially my concern about the JSC and how it does things. I'm satisfied that on the first issue that Judge Mutata raised, that the committee, we are sitting here very clear and the matter has been confirmed. And I'm happy that the issue of the double jeopardy doesn't belong here in this committee. It must be attended where it belongs. And I'm happy with the commitment that the JSC has indicated that it will take up that matter. I therefore, Chair, based on those issues, do want to recommend that we agree and we recommend to the National Assembly that Judge Mutata, the retired Judge Mutata, be removed as a judge in terms of Section 177. And based on our application of our minds, based on the report that we have received from the JSC, where the inquiry took place. Ours was not an inquiry. Ours had a limited role, but I'm very happy that that limited role, we exhausted it to ensure that there's procedural fairness, both from how they conducted that inquiry, but also how we do this. And so I want to move in that regard. I thank you, Chair.
Thank you, Honorable Janchi. Honorable Ngola.
Thank you very much, Chair. Chair, I think now that issues have been clarified to the core, it now becomes a bit straightforward kind of an approach. That we have exhausted all avenues to ensure that what one of Gyanji calls the procedural fairness is actually in application. Chair, I without taking much time, I think Honorable Gyanji has made a conclusion of how do we then move forward, given the milestone that we have traversed with the matter relating to Judge Mutata. So, Chair, I second the recommendation by Honorable Gyanji that we must recommend to the National Assembly that Judge Mutata be removed. Thank you very much.
Thank you, Honorable Ngola. Any other views? Honorable Breitenbach.
Thanks, Chair. Good morning. Chair, yes, Honorable Janki has, I think, summed it up very eloquently, and we agree.
Thank you very much, Honorable Mkhwebane.
Good morning, Chairperson. Chairperson, I think sometimes we just rush, or, well, I was not part of your deliberations before, but then here we're talking about the life of a retired judge who was disciplined by the JSC. Yes, the Deputy Chief or the Chief Justice has written and clarified, and that the matter of the 1 million or the fine which was paid by Judge Mutata will be dealt with by the JSC, which I think as the voice of the voiceless. Chairperson, I think it's a very wrong approach which we are taking as this committee, where we just refer the matter to the National Assembly to recommend for the removal of Judge Mutata, and the person has shown even remorse by paying that money, and he's a retired judge. Where is Ubuntu? I mean, to just deal with the Africans like this, I don't think it's the proper way of dealing with this thing. Why can't we at least give them an opportunity again, and we sit with the legal and Judge Mutata, and we hear all the bases of this matter, because I know, yes, the matter was dealt with, yes, it was finalized, but then why do we have to treat this matter as if we are not dealing with the livelihood of a person? Actually, as the EFF, we are not in support of the referral of this matter to the National Assembly, because it's just a very heartless process to think about, because I think we should be applying our mind and not just coldly say this process has run its course, there's fairness. But then I think we should be really thinking what's the benefit or what public interest will be impacted if this matter can be dealt with in such a way that this person has paid that fine, and surely he's was punished for doing that. And to me, it's still linked to this particular process because we're dealing with the same issue. So I think that's my contribution.
Thank you, Honorable Mkhwebane, Honorable Horn, followed by Honorable Maseko Jele, and then Honorable Ngola, in that order.
All right. Sorry, Chair, I'll just put my hand up as well.
Okay, Honorable Swart.
Yeah, thank you, Chairperson. And let me firstly say that I agree with the proposal made by the Honorable Jantjie and seconded by others. But then maybe to respond directly to some of the issues raised by Ms. Mkhwebane, I don't think it would be fair or accurate to at this stage assert that this committee acting on behalf of the National Assembly has not properly dealt with the matter procedurally, or that we've not applied our minds as would be required in taking a decision that is, and that's more or less the only aspect with which I agree with her, which is, of course, will have far-reaching implications for the judge in question. We very specifically wrestled with what would be the proper process to deal with this matter. We erred on the side of caution by inviting representations as to what factors in mitigating we must consider. And we've at every step of the way also asked Parliamentary Legal Services to advise us. So from our side, we satisfied that even though, of course, there might have been other processes that we could have allowed, like, for example, looking into aggravating factors at some point that was mooted by this committee, and we decided against it. The reality is that in now ultimately only inviting mitigating arguments by the implicated judge, he was, of course, given the full benefit of any process, well, the full benefit of being able to furnish us with such arguments and factors. But then, Chair, let me also come to the role and the responsibility of us as members who have all sworn allegiance to the Constitution of our country as it stands. A Constitution which talks about non-racialism, which would then clearly mean that an argument that African judges, as was made by the Honourable Mrgwebane, or let me say Miss Mrgwebane, that African judges should be treated seemingly differently just because they're African judges, cannot be accepted or tolerated in this Parliament. It is the type of statement that flies in the face of our oath of allegiance to our Constitution. And then around her, I would think, rhetorical questions about what is the benefit that could be achieved through this decision, or a decision to impeach, and what public interest could be served. I once again want to say it is amazing that the insinuation could be that there is no benefit or public interest that is being served. This process is ultimately aimed at maintaining, protecting, and if necessary, restoring the integrity of the judiciary. It is a responsibility this legislature has by way of the manner in which impeachment processes has been set up. We are serving the public interest by ensuring that judges who also overstep, like ordinary citizens, are not treated differently. And if we are to be that country which the Constitution proclaims that embraces and upholds the rule of law, then it is key to that specific project to ensure that the judiciary, and remember, the judiciary is, of course, those who serve, but also retired judges, specifically in as far as it relates to their actions and omissions when they were still part of the bench, that they are persons who are fit and proper. And from our side, we are satisfied that ultimately, through looking at the sum of all of the findings that has been made by both the JSC and then the JSC finding as replaced through litigation, that the National Assembly and this portfolio committee, as at this stage the proxy of the National Assembly, is cannot have any other option but to act in accordance with the proposal originally made by the Honourable Jantjie. Thank you, Chair.
Thank you, Honourable Horn. Honourable Maseko Chele.
Thank you very much, Chair. Good morning, colleagues. Chair, I think I would like to align myself with the view that the matter has come to an end and the matter must be just released as proposed by my colleagues. Chair, the issue of the principle of Ubuntu, sometimes it cannot be just used loosely, Chair, because we look at the facts, we look at the circumstances, all that relate to to an issue, or in particular this one, Chair, now we cannot be made feel guilty, for lack of better maybe words, by the statement of Honorable Mkhwebane, because Chair, the judges and everybody who is in this office, they have they take an oath of an office, Chair. They have a conduct that they have to follow. They know exactly, Chair, and they present us, or they must present themselves to the public that they serve in a manner that is not questionable. Because now we are sitting here having to discuss the issue, a very long-standing issue that some of us who were even young, we would never even thought that we will be in Parliament, Chair, for this matter to be today presented before us. Let me just cut this matter short, Chair. I don't think that the issue of Ubuntu, we must use it in this case. We are, yes, really feel for the family of Judge Motata, and also everyone around his life, because this decision is a very difficult decision for one to come to, Chair. It is important that, Chair, we must, all of us, when we do things, we must think for our immediate families, not to put them into disrepute, Chair. In short, I'm not saying Comrade Mkhwebane is wrong for bringing this issue of Ubuntu, but that's how she feels, Chair, and that's how she sees the matter. But at this moment, I want to align myself with the colleagues that, Chair, let's take this matter. Recording in progress. Thank you, Chair.
Thank you, Honorable Maseko Jele. Honorable Mola.
Thank you very much, Chair. Chair, there is no doubt that an officer who occupies the highest office to ensure that the South African law is protected and adhered to has been found on the opposite side of law. Knowing that his conduct is completely against the law he is employed by the state to uphold and protect. As a culmination of that, there is a background. I think someone is on another meeting.
Yeah, I'm not sure. Can you all try and mute other meetings, or ensure that they are on silence so that they do not disturb us here? Thank you. Proceed, Honorable Mola.
Thanks, Chair. So, Chair, as a culmination of that and as a consequence of that, that particular judge was actually found guilty and convicted in a competent court of law, fined, and, Chair, paying your fine money is not showing remorse. You are paying your dues as a result of the consequences of your own conduct. That can be qualified as showing remorse. Three, Chair, you have actually, in a very short form, explained the manner in which this committee applied its mind in relation to the matter at hand, and how far it has went to ensure that Judge Motata's voice is equally heard and his written response received by the committee. Inclusive to that is the JSC. So that we're able to apply our minds, informed by factual issues at our own table. So that's why we have applied ourselves this way, because we have been able to afford both Judge Mutata and the JSC an opportunity to make representations to the committee, and further called upon the Parliamentary Legal Services to give us the sense of law in relation to the matter at hand. So from where I'm seated, Chair, the committee has done its own procedural fairness process. So that's what makes the committee to arrive at this in this particular time. Hence, I disagree with any member that says we've rushed this matter. We have not rushed this matter. We have applied our minds properly. Procedurally, we have actually outdid ourselves. Chair, I come from an organization that is biased to the motive forces. And the motive forces, Chair, are those that which stand to benefit the most in the gains of the revolution. And from where I'm seated, Chair, a judge does not qualify to be part of the group of a strata of society that is called the voiceless. A judge, Chair, has got every resource to capacity themselves to argue their cases in a court of law. But we've got a strata of society that lives in the rural bundles, there's nothing, whose only legal representation is dependent to legal aid. That's the strata that we may call the voiceless in relation to the context at which the matter is raised here. So, Chair, I want to reiterate my point. This committee has applied its mind and it has applied itself properly and therefore must proceed as recommended by Honorable Gyanti. Thank you very much, Chair.
Thank you, Honorable Ngola. Honorable Swart.
Thank you, Chair. Yes, just very briefly, the ACDP aligns itself with the other speakers in supporting the impeachment of retired Judge Mutata. We, as a committee, we firmly believe that we followed the due process and applied our mind to the case under consideration. Thank you, Chair.
Thank you very much. Members, by a majority view, we will recommend to the National Assembly that Judge John Mutata be removed from office. Thank you very much. Can we move to the next item? Because of the high levels of unemployment, I think not...
Chairperson, sorry for budging in. It should be clear that the EFF vehemently is opposed to that.
You had already made, I think, that point known. That is why in my summation, I said by the majority decision. I did not put a thought that says we are unanimous. I said by majority decision, the committee would recommend that Judge John Mutata be removed from office. There's a hand, Honorable Maseko Chele, Honorable Janji.
No,
I was on the next item, Chair.
Oh, okay. No, just maybe before you come, Honorable Janji. Let's allow Dr. Lutz just to take us through the process, especially the latest letter that we received from Judge President Hlophe. But I must just say that we gave the same timelines to both Judge Mutata and Judge Hlophe. We first gave them the first opportunity to make representations, and when Judge Mutata asked for an extension, that was extended also to Judge John Hlophe. We have received 2 correspondences from Judge Hlophe. The first one was, in fact, but even the second one, but the main issue that he has always been raising is that we cannot say that the process is ripe for a decision. He is arguing that he has appealed, and therefore we cannot take judicial notice of the decision of the JSC. Dr. Lutz took us through all that and the responses that High Court Judge Sutherland's blow-by-blow responses to the letter. And then there was a second letter that Judge Lope wrote. And that is what I think before we deliberate, Dr. Lutz will take us through that letter. Dr. Lutz? So I did not want, given the high unemployment rate in our country, that I render you unemployed, Dr. Lutz. So that is why I'm giving you this opportunity to be employed.
Thank you, Chair. Chair, I think I'm not going to burden the committee with repetition from my side, not your side, Chair, because as Chair said, I've already presented fully on the litigation and the judgments that brought us here. Perhaps just there was some repetition in Judge President Slope's representation. So just to be fair to him, I'm just going to highlight certain aspects again. Like Chair said, he mentioned that there's a pending appeal, and therefore the merit arguments has not been settled and the committee cannot proceed. Chair, we respectfully disagree. We have actually consulted with senior counsel on this, and they agree with us that there is a legitimate decision for the committee to consider here. It's been referred to the House, it's been properly processed. When there was a leave to appeal application on the High Court judgment, the judge it was a three judge bench. They actually said in allowing appeal to the High Court that then to the Supreme Court of Appeal that they're not doing so because they think there's the possibility of success. They specifically said they did so because this is maybe the first time that this has happened, and they'll allow it in the public interest. But in no instance that the High Court give the understanding that in allowing Judge Slope to appeal, that they're saying that they find that there's grounds that would succeed. So perhaps just to say that. So in consulting with senior counsel, they said there is currently a legitimate decision before the committee can proceed. If at any stage something changes and it's set aside, there's no financial burden here. The committee is not running an inquiry. It's not running up expenses. It's doing what it is constitutionally required to do. The Constitution says when there's a duty on Parliament to act, it must do so diligently and expeditiously. And absent an interdict, as we said, and this was also confirmed in numerous cases and by senior counsel, absent an interdict to stop Parliament from executing its constitutional mandate, there is an obligation on the committee to proceed. So just to indicate, just to again reiterate that, Chair, the Judge Lope also asked for an opportunity to make oral representations as presented in the step-by-step. This is not an inquiry process. He's now had 2 opportunities to make written submissions. They have been quite extensive, and they have been extensively considered by the committee. It is our respectful opinion that written submissions in both the judges' case is sufficient for this process. Judge Lope again appealed to the committee to run its own inquiry into the JSC process and to make its own finding as to gross misconduct. That, Chair, our office is advising that would be against the constitutional mandate that the National Assembly is called upon to exercise in Section 177. So we advised against that. Judge Lope has also asked that the committee intervene with the financial issues he's experiencing with the DOJ and the State Attorney. Chair, respectfully, it's not for the committee to get involved in litigation management issues. The committee's task here in terms of 177 is to make a decision on what follows from the JSC inquiry. Then Judge Lope also again highlighted concerns of political views already expressed. This is a political forum, and the court has made it clear that this is the political decision phase of that. Absent a clear indication that it's something else. I can't see how that argument would hold. Also, that similar argument was put in, to the court in the Sutherland judgment, which was discussed. And even there, with the Premier of the Western Cape, the argument of political views was brought up, and the court said that it could not hold that there was a conflict of interest, as there was opportunity made for political representation during the process. So, Chair, just to perhaps reiterate those, then the extenuating circumstances put forward by Judge Hlophe, again, he is alleging undue political pressure. And these circumstances I took from his letter. It's for the committee to weigh how much weight it would like to place on it or not when deciding on the consequences. So he's alleging undue political pressure. He said that some people actively pursued the JSC process to get an outcome against him of a finding of gross misconduct. He made reference to Justice Kriegler and said he allegedly publicly trumpeted a campaign to secure the outcome to remove a sitting judge president whom he disliked. So that was an example he gave as to active pursuit of his removal. He says it's in the public interest for the committee to not proceed with the deliberations as to possible removal. That's for the committee as the publicly elected representatives to consider. There we go. He also again raised the issue of Justices Nkabinde and Jafta, who did not seek a finding of gross misconduct against him. Chair, as explained also with the Sutherland judgment, the judges there said that when it came to the JSC process, whether Justices Nkabinde or Justices and Jafta wanted a gross misconduct finding or even wanted to bring a complaint was neither here nor there. The task of the JSC was to consider whether there was gross misconduct, regardless of what Justice Nkabinde and Jafta would have liked as an outcome. But here it weighs in a different aspect. Here it is for the committee to decide whether it's extenuating circumstances, because it doesn't, here we're not now speaking to the finding, we're speaking to the possibility of removal, whether the fact that Justices Nkabinde and Jafta did not seek removal on the grounds of gross misconduct weighs in any way or form, and that's up for the committee's consideration, Chair. Chair, then also Justice Hlophe spoke to the qualifications he holds from various universities, both in South Africa and internationally. He has a B Juris, a LLB, a LLM, and a PhD. The PhD, if I recall correctly, is from Cambridge. And then prior to taking to the bench, he also lectured at the University of Zululand, University of Natal, and the University of Transkei. He says that currently he is the most senior judge, having served 28 years on the bench. And he did so he says dutifully until December 2022 when he was suspended. He actively served as a judge president for 23 years. He says he's a well-respected academic, having published and presented numerous papers and chapters and books nationally as well as internationally. He has served as a member of the South African Law Commission. He says he has delivered many reported judgments which have been referred with authority in a JSC and Constitutional Court judgments. And he says he is still held in high esteem by many jurists and scholars. Chair, that's in a nutshell the summary of the letter that was circulated to members. That is Judge President Hlophe's submissions for extenuating circumstances. And Chair, it's completely up to the committee what weight members would like to assign to these aspects. Chair, I think that is as much as I can contribute at this moment. Thank you, Chair.
Thank you, Dr. Lutz. Can you remove the slides? Thank you. Members, that is the presentation from Dr. Lutz. Honorable Janche.
Thank you very much, Chair, and appreciation to Dr. Lutz for, again, taking us through the kind of work that would have gone through. I'm not going to repeat the framework issues that we had raised. Perhaps to start in appreciating that after you would have given both judges, Mutata and Hlophe, Judge Hlophe would have responded very comprehensively. on our issues on both occasions. I had to spend some time, Chair, going through the latest 244 pages of responses and argument from Judge Hlophe as to why we should do the kind of things that he was suggesting. And for the record and for emphasis, having also listened to Ms. Lewis, it's only just fair that I would list, because these issues would have been repeated both in the first response and the second response. And just about 6 or so of those as headlines that we need to take note of, that from where I'm sitting, I would have applied my mind to. Judge Hlophe would have raised with us that the matter in front of us is not settled for the NA to deal with it as a first and the main reason. And that he would have secondly raised that the issue of the concerns, the impact of the cost on appeal. As Ms. Lewis was saying, thirdly, that he is asking us as Parliament to consider the finding, almost short of saying, let's do our own inquiry as Parliament. And the Section 177, unlike Section 194 and Section 89, doesn't allow Parliament, the National Assembly in this case, to do a separate inquiry. The inquiry is done and concluded by the JSC. Ours is to receive the outcome of that and be interested in the procedural fairness, both of that inquiry itself, as well as the matters that would be in front of us. Judge Hlophe would also raise with us that he would have presided over the election of the Speaker. In other words, then trying to indicate to us that there's a problem with the Speaker, the person who has referred the matter to us, that he would have presided over that. These are some of the issues that he would have raised. Ms. Lewis has raised this issue again of saying that Judges Nkabinde and Jafta were unwilling participants and wanting this oral representation. And basically on all of those issues, Chair, the Southern judgment, the JSC and how it has reached this gross misconduct, all of those questions and issues raised by Judge Hlophe have been answered comprehensively. I am of the view that one is satisfied with, because it was important that we attend to the issues. We don't close our eyes on the issues that were raised. And you would have given us time. You would have given them time to place those matters. And having received their final responses on those, nothing changes to persuade, to convince us in recommending a political decision that we should be doing something different from the finding of a gross misconduct. Especially for Judge Hlophe, Judge President Hlophe, the issue of the independence, of the judicial independence, as enshrined in Section 165, is a serious matter that I think as members of Parliament, we should be considering. I also agree that there is no legal impediment. We have no interdict in front of us not to proceed. I therefore, Chair, and I want to be mindful of my language here, because in the context of our own constitution and our lexicon in the country, we have nothing about impeachment. I therefore want to be very specific that Section 177 is about the removal of the judge. I don't want to get into this colloquial language of impeachment. In the US, they do that. I therefore want to affirm that indeed there is gross misconduct by Judge Hlophe, and therefore I propose that we recommend to the National Assembly as part of his political decision that Judge Hlophe be removed from the bench. I thank you, Chair.
Thank you. Honorable Horn.
Thank you, Chair. Let me firstly say I would consider myself properly chastised by the Honourable Jantjie for the use of the term impeachment. I will refrain from doing that again. Chair, I align myself with Mr. Jantjie's comments and arguments. I just want to add, I believe, two additional issues or submissions on two additional issues. The first is the argument by Judge President Klope, as also tabled by Ms. Lewis, around the fact that in his view it's in the public interest for Parliament not to proceed with finalizing this matter. Now, let me firstly say it's in my reading of his submission largely a unsubstantiated argument, but for as far as it is necessary and for as far as it would seem the argument is that it's then in the public interest not to finalize this until a possible appeal has one day been finalized. I think we must just place on record or maybe deal for a moment with what the public interest is. And Black's Laws Dictionary say that something is only in the public interest if the general welfare of the public warrants a recognition or protection, or in our case then specifically, I would think a specific decision. And if in something in which the public as a whole has a stake, especially in the interest that justifies a governmental regulation. Now with the greatest of respect, one would I think very rarely find that the plight of an individual, and specifically an individual in respect of whom an exhaustive fair process has unfolded over more than a decade, to come to the point where a finding of gross misconduct is made. I would think very rarely could there then be an argument that in the face of all of this, it's in the general public's interest not to finalize it. So I would want to argue that as a matter of fact, it's in the public's interest, if one looks properly at what public interest is, for this matter to now be concluded, specifically the long history and the fact that at some point this specific matter was used as an argument that the judiciary saw itself as above the rules that apply to the general public. And in that sense, we must clearly understand, despite the delay, the urgency of the matter as we are now seized with it. The second point I think that must be made, Chair, in respect of the record of service and the academic record of Judge President Klope as tabulated by him in his submissions, and Dr. Lewis has said that we must as a committee decide what weight we are to give to it. I just want to also put on record that, of course, the difficulty for Judge Klope in tabulating both his very distinguished academic record and objectively speaking, his record of impressive service initially as a judge with high quality judgments, the fact that he contributed to the jurisprudence and the body of law of this country as a judge, works unfortunately not only in mitigation but also in aggravation, in the sense that certainly no individual with that type of record of good service, of distinguished service, can argue then that an act of misconduct, and as a matter of fact, an act of gross misconduct, must be excused merely because they have a record of distinguished service. It works. This is a knife that cuts from both sides of it, and it is quite clearly also so that there is no room to argue that this was a momentary lapse of judgment, and therefore I agree with the Honourable Jantjie that we are bound by the findings, the ultimate findings of gross misconduct, and are under an obligation to advise to the National Assembly that the only suitable way forward is removal from office. Thank you, Chair.
Thank you, Honorable Ngola.
Thank you very much, Chair. I think, Chair, the committee in its deliberations must take into consideration the fact that this matter has been dragging for far too long. It has been dragging in and out of courts and out of the JSC since 2008, which I think that in itself is not fair to Judge Hlophe, whose life is on pause, because he's supposed to give his full attention to the matter. It's equally not fair to the South African judiciary, the JSC, the legal profession, and the entire people of South Africa. There is a moment, Chair, if you you follow the trend of this matter, where for over 6 years, the JSC had to halt its process to await the court to adjudicate on the matter, which the last court judicial decision on the matter was on the 5th of May 2022, which is a culmination of why the matter was referred to us. And I think, Chair, quite honestly, the committee has once more applied its own process of ensuring that Judge Hlophe is afforded an opportunity to argue his case, to put his facts before the committee, so that at any stage when the committee is deliberating on the matter, it considers the issues that are raised by both the JSC and Justice Hlophe, which I think, Chair, qualifies to what we call the procedural fairness. No, myself, Honorable Jantjie, and Honorable Mkhwebane has had a very long time getting teachings on what then is a procedural fairness. And I think from the teachings that we have got in the past year, we actually have a better understanding of when our process is procedurally fair. And I think from the journey this committee has taken and the effort it has made to ensure that Justice Hlophe is heard, his voice is heard, it actually qualifies as that. Chair, Section 177, 1A of the Constitution gives us one condition where a judge may be removed, which is when they are found by the JSC on 3 counts to be guilty. And amongst those 3 counts, Chair, is gross misconduct. And as we sit here today in this committee meeting, Chair, we have a report that the JSC, the Judicial Conduct Tribunal, has found Judge Hlophe to be guilty of gross misconduct. So I think it is quite fair for us to do what is procedurally on our table, which is getting the report of the JSC through its tribunal and recommend and agree with Honorable Jantjie that we shall take the matter to the National Assembly and recommend that Justice Lope be removed. And I agree with Honorable Gyanji, Chair, that in terms of Section 177, there bear no obligation to open any inquiry, but that to receive reports from the process the JSC has followed and actually navigate if the JSC has not violated any rights of the person who was accused of committing misconduct. And from what we've gotten from the JSC, from Judge Lope, which my colleagues correctly call it a comprehensive response, and a legal brief from the from the Parliament Legal Services. So I think, Chair, we have gotten the satisfactory factual issues relating to the matter, and I agree that, Chair, we recommend to the National Assembly that Justice Lope be removed. Thank you very much.
Thank you very much. Is that all? Have all members spoken who wants to speak on the matter? Thank you very much. We will recommend.
I must raise my hand first.
Yeah, it's important, Honorable Mkhwebane.
Chairperson.
Yeah, noted. Over to you.
Chairperson, I hear the presentation of Ms. Lutz. I don't understand. Okay, possibly you'll just also indicate who is Ms. Lutz? Was she appointed by the committee to advise on what? But now she's here, she has presented, she was your lecturer or something. Secondly, Chairperson, I hear you speaking about the issue. In fact, she's speaking about the issue of the SC who advised on the matter. Who's that SC? Who appointed that SC and who paid for that SC? Yes, I saw there was a legal opinion which was shared. The name of that particular person, I don't know whether that's the same SC she is referring to. And, you know, the issue of this process anyway, because one has been through it, and it's as very grievous and heartbreaking as it is, where you find members of parliament who will say the process was fair, when the matter, it's still, the court granted Chief Justice Lope the appeal, and now the issue of justice not funding his appeal when the court has granted the appeal, it's also an issue where you would say, is that a fair, it's not part of being fair or the process being fair. So, and the issue of the gross misconduct, Chairperson, is still not yet finalized. Again, considering what the issue of the merits of the issue were not settled because it's been granted appeal. And I don't know what happened to the issue of Rule 89 of the National Assembly, which talks about that no member may reflect upon the merits of any matter on which a judicial decision in a court of law is still pending. So the merits of this issue have not yet been finalized. And we are saying no, this issue must be taken because National Assembly has given us that opportunity to advise them to take matters when they are complete and truly finalized. Unfortunately, yes, that's not what these members who have said we should be proceeding with this matter are concerned about, because the issue of fairness to them, because it doesn't apply to them, they think everything has been done. But then, I mean, this matter must still be heard before court. Uguti, this matter has long been on the process, and it's even worse because the issue of what Chief Justice, in fact, Judge President said, not going back to the hearing, JSC and everything, is the fact that the two judges speaking in the African language, ukuthi sesithembeleke nina. So umuntu who has delivered so many judgments, who has even lectured and has vast experience in the judiciary, and just like that, the matter is pending before court, and we are still even saying no, we are not interested about his funding, because it's still part of the process. It's for us to make sure that there's complete fairness in how he's being treated. So I think, Chairperson, I would still plead with this committee that let's give this matter an opportunity to be completely ventilated in court, and to even request the Department of Justice, because they report to this committee, to avail the resources so that this matter can be heard and it can be completely dealt with. It's so unfortunate again, because a lot of the issues which are there in the report and the deliberations which were taking place at the JSC are still also relating to the very same, some of the court judgments, which I think that opportunity is still raising them with the appeal court. And if it means as well taking it back to the Constitutional Court, that's something which Chief Judge President would still raise. I'm always saying Chief Justice because possibly it's the Chief Justice we never had an opportunity to have as a country based on his expertise and experience. So I think fairness goes a long way, and the perception of bias goes a long way, because it's what you as the person who's accused feels. It's not the people who are supposed to be judging you. So I would then say, Chairperson, let's not just use the numbers, let's just use the factual issues and deliberate on this particular issue.
Thank you. Before Honorable Moll and Honorable Janji, Honorable Mkhwebane, were you expecting direct answers on who Dr. Lutz is?
I would appreciate that, Chairperson, because yes, it's the first time interacting with her. How was she appointed? What is her role? And the SC is the one we received the legal opinion from, and who paid for that SC?
Dr. Lutz is a parliamentary advisor, and assigned to assist committees with legal opinions and to advise the committees on procedures and the law. So for the purposes of this process, she was assigned to assist us as the portfolio committee. So she's employed by Parliament. She's a legal advisor supporting committees.
Supporting advocate at Hikare. Chief Parliamentary Advisor. Okay.
Advocate at Hikare is the chief, so they work under her. They work under her, but they support committees. But to the extent that I was saying she was my lecturer, it was just a joke. She has never lectured me, but it was just a joke. But she is the person who assists portfolio committees. She has assisted us not once, many times. Dr. Lutz, you can just explain the issue of a senior counsel.
Thank you, Chair. Chair, the Sutherland judgment that I referred to, Parliament was cited as a party in that case. We filed a notice to abide with an explanatory affidavit, which was prepared by Senior Counsel Stephen Butlander, following the judgment to do due diligence in considering what the impact of the process going forward would be on Parliament. Advocate Butlander then provided us with an opinion to clarify. We specifically asked them what would the impact of the appeal application be on the process of Parliament. And it's in that context in which he then provided that opinion. The opinion is not for the I want to say for the purse of the committee. It was as a consequence of litigation management, which our office was involved in, and it was to do due diligence for the overspill of that process in that. Chair, if I can perhaps just highlight for clarity, perhaps I should have done so earlier, from Advocate Butlander's opinion. He referenced the City of Tshwane versus AfriForum, which is a 2016 Constitutional Court judgment. And in that, the court said it needs to be stated categorically that no aspect of our law requires of any entity or purpose to a person to desist from implementing apparently lawful decisions simply because an application that might even be dismissed has been launched to hopefully stall that implementation. Any decision to that effect lacks a sound jurisprudential basis and is not part of our law. It is a restraining order itself, as opposed to the sheer hope or fear of one being granted that can in law restrain. To suggest otherwise reduces the actual grant of an interdict to a superfluity. Advocate Butlander then said that was the case in respect of whether an organ of state could proceed in the face of a pending High Court application. The position must be even stronger in respect of the present situation, which is the matter of Judge Hlophe, where a full bench of the High Court has already dismissed the application, and the debate is what must occur pending appeal. The debate then being the deliberations that is currently before this committee. I hope that assists to clarify, Chairperson. Thank you.
Okay, Chairperson. The same Butlander.
Sorry, Honorable Mkhwebane, please raise your hand if you want to speak. Honorable Ngola.
Chair, thank you very much, Chair. The committee meetings are public meetings, and they are on record. So I would feel guilty if I would not raise this point, because it will send a very incorrect message to the public. The committee did not say it doesn't care about the funding of the legal issues of Justice Hlophe. But the only thing that was stressed was that matter does not fall within the jurisdiction of the powers of this committee. So it's not a matter of us wanting or not wanting, but it's a matter of the doctrine of separation of powers. It truly does not rest within the powers of this particular committee. That's the message I think the committee is sending. I think we must focus in facts and the applicable law. In some of the things, Chair, we may argue them until the end of the decade, whether this person should not be found guilty of gross misconduct on the basis of their contribution to society, and on the basis of how good they are, and on the basis of how do we think they're progressive, and on the basis of what race they fall within. But we deliberately, Chair, did not want to take that line, because it's a line that will be unwarranted in accordance to what is required of us in this committee meeting. The Constitution, Section 177, gives us a condition that a judge may be removed if found to have committed, amongst other things, gross misconduct, and to operate in accordance and in terms of the prescripts of law. And Chair, From where we are seated, we think that the matters have been ventilated throughout. To understand that, Chair, from the reports, there was a judicial review application by Freedom Under Law, which was lodged with the court in 2020 and adjudicated in May 2022. So the matter has been ventilated in both the JSC and the courts of law. So having applied our minds to what has been given to us as a report from all these bodies that are relevant to the matter, therefore this is our consideration that in accordance to what we are instructed to do by Section 177, we ought to proceed with the recommendation as proposed to the National Assembly. I think other things, other political statements, Chair, they are matters of argument that if we focus solely on them, they may take us out of the road that was supposed at this committee to actually deliberate on. Thank you very much, Chair.
Thank you, Honorable Mkhwebane. Honorable Mkhwebane, your hand is up.
Yes, Chairperson. Okay, I was waiting I saw Mr. Janchi's hand was up. I thought you will recognize them.
Please proceed.
I'm still repeating, Chairperson, that the process is not complete. The matter is still before court. The appeal was granted. It should still be ventilated. So, and it's a concern, Chairperson. I think, Mr. Ngola, when you say regarding the color of the individual and everything, and what Mr. Horn said earlier, I didn't just want to respond to, but because this matter now is dealt with by politicians, Chairperson, we seem to be just going with whatever, you know, I mean, listening to Ms. Lutz about Advocate Batlenda SC, the very same Batlenda who has been representing DA in a number of other court cases, including the issue of the removal of the public protector. So, and what the Judge President Hlophe, the matters he dealt with, and how he's been treated in the Western Cape, the report on racism. So his matter is still before court, Chairperson. Not to say this matter has been completely dealt with. So my issue is, I think let's give the appeal an opportunity to be dealt with and ventilated. And I still repeat that Justice Department accounts to us. Therefore, there's nothing about the issue of interfering and whatever, but it's still one process. Let's make sure that he is fully and properly funded to defend his case. That's all what I'm saying, Chairperson. And I think it will not be fair or procedurally fair and constitutionally fair to Judge President Hlophe if the matter is still before court and that process is not finalized. So as the EFF Chairperson, we just plead with you to give this process an opportunity to be fully ventilated in court. Thanks.
Thank you, Honorable Janchi. And then I saw Honorable Horn's hand also.
No, thank you very much, Chair, and I appreciate your leadership and patience with us, because that's how we run this committee, so that all of us get an opportunity to express our views. I sympathize with the position that has been raised by the EFF through Ms. Mkhwebane, but it's not even close to being stronger to what Judge Hlophe would have raised. I remain very much unpersuaded by it. The issue here is that we should avoid, Chair, focusing on incidentals. We have a framework, there are issues that we must attend to. This matter is not a personal matter that we're dealing with. And so we should even avoid creating a binary of those that out of this meeting must be regarded as we love this judge, we hate this judge, we don't love. There's nothing about that. We're here considering the facts and evidence in front of us based on our role as the National Assembly as part of Section 177. I mean, for example, the issue of interdict. The main purpose of an interdict is to assist an aggrieved person to either compel a person or institution or prohibit that person or institution. And Judge Hlophe has got that tool, has got that instrument to himself. If the arguments that are raised by Honorable Mkhwebane would be the argument that he raises, he's free to do that. There is nothing, we're not going to operate on the basis of the feelings. And because it now borders into really close to blackmailing our own discussion, which is focused on fact. If there's a relief sought, Judge Hlophe, there's nothing that stops him from doing that. Even the issue of the appeal, there's nothing that stops him from proceeding with that. You can imagine if we're now going to be not take decision, not only on this matter, on a number of other matters, if we're to allow and listen to those arguments. Was our role in terms of Section 237 of the Constitution, those of us who have taken oath are constitutionally bound to proceed with this matter diligently and without delay. You're dealing with a 15-year-old matter here before it came to us. And I'm happy that as Parliament, we're not even 5 months onto this matter from the time that it came to the attention of this committee. And therefore, we're expeditiously attending to every issue that is there. I think, Chair, we must note the issues that have been raised by Honorable Mkhwebane. If there are any other issues that can be sent to us, clarity that must be done. But I don't see anything else that otherwise we're going to have an argument for the sake of having an argument. As far as I'm concerned, and including court outcomes, the process that has been presented to us, the matter is settled. It would not have come to us if it was not settled. Our role as this committee and the National Assembly is not to reconsider or litigate what would have happened. Our role is to now apply our minds in terms of what is in front of us, and we've, for me, done that sufficiently, not only this morning, even before that. And therefore, I want to therefore appeal to you, Chair, that having listened to us, having been patient, I think it's important that we wrap up the matter. We are not glossing over any issue. We are thorough, and I'm very confident about that. Let's recommend to the National Assembly that Judge Hlophe be removed for committing gross misconduct. Thank you, Chair.
Thank you. Honorable Horn.
Yeah, thank you, Chair. I am largely covered by the comments of the Honorable Jantjie around the absolute need that we as members of this committee should not allow for, I want to say, personal baggage to cloud our judgment in this regard. Let me maybe also then, therefore, restrict my comments to simply say this. I think the AfriForum case, as quoted by Dr. Loots, is of course instructive to us in the sense that that would mean that there is no legal impediment on this Parliament to finalize the matter in the circumstances. I agree with the Honourable Jantjie that in the event that at least if there was some movement in respect of this appeal, one would have thought that would have indicated a bona fide intention to proceed with it. In the circumstances, however, there is no such movement, and therefore, I would think the remarks about the fact that in some cases an appeal is ultimately lodged for the sake of trying to delay the inevitable might be of relevance to us as this Parliament. The long and the short is, however, that as has been pointed out, it's not as if this process, if it's seen from start to finish, and in referring to the process, I'm not only referring to Parliament's process, I'm referring to the totality of the process. It can never be argued that this was rushed in any way or form. I mean, as has been said, to the contrary, the public out there would not be unfair to public office bearers, and in using the term public office bearers, I'm including members of the judiciary as well as members of Parliament, to say that public office bearers seem to hold themselves to a different standard than the general public is being held to when it comes to dealing with matters like this. And on that score alone, we are under an obligation to finalize this now. The Honourable Jantjie is technically correct in saying that this committee is now, since being alerted to the fact that the appeal has seemingly stalled, has expeditiously dealt with the matter. But of course, the matter was referred to us much earlier, where in the interest of fairness, there then was seemingly an agreement between the Speaker and the legal representative of Judge President Globe that Parliament will pause processing pending the finalization of the appeal. And if that is considered, the fact that the appeal has stalled on the basis that the Judge President don't want to pay for the preparation of the record himself, must ultimately lead to a situation where, despite what the case law might say, we are now confronted with a situation where factually the appeal is going nowhere. And in that sense, even if one might have some sympathy for the argument of Ms. Mogulbani that all avenues have not been exhausted, I think it will be, Parliament will make a mockery of itself if it on that basis decides to further pause the matter. So therefore, I agree that if all aspects of the matter is properly considered, we are under a constitutional obligation to finalize the matter firstly, and then secondly, given all of the information available to us, I agree with the other speakers who have argued that we have no other option but to advise the National Assembly that the Judge President must be removed from office. Thank you, Chair.
Thank you, Honourable Horn. Honourable Mkhwebane.
Chairperson, as the chairperson of this committee, I think one is free to raise issues, and I don't think it's for Mr. Jantjie to just conclude and say the matter has been dealt with. I'm still putting points across, and I'm also making sure that we check all the facts before us. And definitely the process took long, but it's not long with the committee. He's correctly saying 5 months. Yes, the Constitution demands of us to deal with matters expeditiously, but it also has to take the issue of fairness, equality before the law. Now, Mr. Horn, you're saying Mr. Hlophe must pay, or Judge President is the one who's stalling the process. Chief Justice, Judge President Hlophe is still is having challenges with justice paying for the appeal. How would he have the resources to then interdict the process? The appeal is going ahead, so justice must pay for that. Chairperson, we are a committee which should be seen to be operating fairly and without any questionable doubts. And again, bringing the issue of race, Chairperson. Yesterday, we were dealing with the TRC matters. Yesterday, we were told by the NPA that some matters are delaying because state attorney is delaying or refusing to pay for the one of the perpetrators, an apartheid police who murdered one of the freedom fighters. Now the state is paying for that particular person. So we can't intervene and say, justice, make sure that you pay for the appeal, for the record. Why must Hlophe pay from his pocket when the state has been paying? Why withdraw and frustrate him? So it's for us as the committee to intervene and give the process so that the matters are fully ventilated, because the merits of the case are still hanging due to the fact that the matter is before court. So that's all I'm just saying, Chairperson, that I'm just raising all these facts for us to check and to be clear. And with deliberating here, we are not supposed to be, or just be told, no, the matter is decided, person, let the person be removed, be referred to the National Assembly and the matter be dealt with. So that's all what I'm just raising with you, Chairperson, that let's just be considerate and consider all those facts.
Thank you, Honorable Janche.
I've listened again, Chair. I think it's not helpful just listening to Ms. Mkhwebane repeating the same thing. Not persuasive at all. In fact, I take exception about what she said before. It seems that if she loses this battle and the discussion, the issue of her saying that because of numbers, we're not dealing with numbers here. We're dealing with facts that have been presented in front of us. It's the content and substance of the issues. And I don't think she must even go there. But Chair, I think it will be a waste of time for us to just stay on the same matter. I would, if there's anything that, in fact, Honorable Horn made the point to enhance the point I was making about the 5 months, correctly so, that this committee, when the matter was first referred, we paused to give Judge Hlophe this ample time for the appeal process. The reason why we only started 5 months ago, it's because that would have come to a cul-de-sac. And Ms. Mkhwebane now says we must go back to that cul-de-sac. You wonder perhaps what would be the intention for that. We are very clear, we've put a framework, and in that framework we said everybody else would be allowed. Judge Hlophe has given us every reason in writing, comprehensively so. We've considered that. I don't think that we must now start doing side shows instead of focusing on this matter. I still maintain, Chair, that I think we've exhausted the discussion on this matter, and I still recommend that we proceed as earlier recommended. Thank you.
Thank you, Honorable Breitenbach.
Thanks, Chair. Yeah, I agree with all of the previous speakers besides Ms. Mkhwebane, and for her to suggest that the that the committee now get involved with the funding aspect of Judge Lopez's fugitive defense, I cannot agree less. I don't see any point in rehashing this issue over and over again. We've heard the legal advice. It's sound advice. We've heard the advice from senior counsel. It's sound advice. This committee has bent over backwards to be more than fair, and I think we should move on. Thank you, Chair.
Thank you, members. We have come to the end of the discussion. The committee, by majority decision, will recommend to the National Assembly that Judge President John Madlawaisa Hlope be removed from office. Thank you very much. Can we move to the next item? Briefing on the hate crime, hate speech. Ms. Pillay, or the Deputy Minister.
Yeah, no, Chair, I'm back. Judicial matters went quick and it won't be coming back here. I think it's Ms. Pillay, DDG Pillay is here. There is a present, but it's going to be Mr. Dupria, I think, although I can't. Yes, he is online. But if Ms. Pillay is online, because I think things went quicker, I'll hand over to her. Otherwise, if she's not, then to Mr. Dupria to take the committee through the NCOP amendments. Thanks, Chair.
Thank you, Chair.
Thank you, Chairperson, and good morning to you and the members. Mr. Dupria and Ms. Alison Botha, who dealt with the bill through the Portfolio Committee, and then the Select Committee will take us through the changes. Thank you.
Good morning, Mr. Chair and members of the committee and Deputy Minister. If you will allow me just a second, I would like to share the screen with you. Mr. Chair, I'm going to share two documents with you. The first document is actually the last working document that was presented to the Select Committee, and that was as a result of a consultation that took place, public consultation, public comments that were received, inputs from the committee, and then also inputs from the National Prosecuting Authority. So to a certain extent, there were three main streams of comments that the committee received. And once again, Mr. Chair, please stop me if I'm going too fast, or if you would like to maybe pause on some matters. The first set of proposed amendments, Mr. Chair, is with regard to the characteristics definition. That is purely technical, a language amendment that's to be made there. Just to clarify, the blue highlight is something that came from the committee and the committee advisors. It's just once again a technical amendment. Then when we get to the definition of court, Mr. Chair, this is an important one. The proposed amendment is to delete the definition of court, where it was restricted to the regional court and the district court, but the NPA expressed their concern with regard to the number of cases that may arise, especially those cases that are traditionally now currently being prosecuted in the district courts. And the committee agreed that it might be more appropriate then to recommend to your committee to delete the definition of court. With regard to the definitions of Criminal Procedure Act, Director of Public Prosecutions, and the definition of National Director of Public Prosecutions, Mr. Chair, those are also technical to an extent that we feel that it might be it should not be necessary to define those terms, because they are not used that much in the Act itself, or the bill itself, in the substantive provisions. And then, of course, to a certain extent, there cannot be any doubt with regard to who a Director of Public Prosecutions or the National Director of Public Prosecutions are. So those definitions are actually self-explanatory and to a certain extent then unnecessary to include in the definitions clause of the bill itself. Chair, my apologies. I just don't know what happens to me, but every time when I'm in your committee, my voice tends to give me problems.
I think it's Honorable Breitenbach.
Don't allow her to intimidate you, please.
Oh, when I intimidate you.
Thank you, Chair. And then clause 2, there are no proposed amendments with regard to that clause. And by the way, the Portfolio Committee was also very was satisfied with the clause itself. So that's one of the long surviving clauses, if I may call it that. With regard to the offence of hate crime, Mr. Chair, once again, something that we as drafters would like to put forward as a technical amendment, the inclusion of the words person with one or more characteristics, or a then reference to...
Sorry, Mr. Dupree. Are we not dealing with a bill as adopted by the NCOP? If that is the case, then you as drafters, where do you come in? Because we should be dealing with the text from the NCOP.
Sorry, Chair. Maybe that was that was a slip from my side. The committee is now dealing with a bill as adopted by the select committee with proposed amendments, of course, and we're highlighting the proposed amendments to you. Chair, I apologize.
Sorry, Mr. Dupree, not from the Select Committee, from the National Council of Provinces. It went from the Select Committee to the House. So this is the bill. Obviously, it was the same version of the bill, but this is the bill from the National Council of Provinces.
Yes,
well, Chair, I must admit that being corrected twice in 2 minutes is a bit harsh for me. I was intending to present the report as well.
All of us was also corrected. That is not...
no, fine. Thank you, Chair. Thank you for your indulgence. Yes, sometimes when we work a lot with this, we tend to skip the technical language. Chair, then with regard, that is those are the most important amendments that are proposed by the NCOP or as approved by the NCOP. With regard to the victim impact statement, there was just this technical proposed amendment in subclause 2A by the National Prosecuting Authority. The more important one for us at this stage, Mr. Chair, is the proposed amendment in 2B, and that was an amendment that was proposed or comments received from the Hate Crimes Working Group, where they have indicated that there might be if I may call it, a loophole with regard to that provision, to the extent that where a victim may have passed on, that someone else may have to be placed or should be placed in a position to then present an impact statement. The very important one then is the proposed amendment to the penalties, and that relates to the proposed offence of hate speech, Mr. Chair, and it was highlighted in the select committee as blue because it was something that was argued and debated and discussed in the select committee. The select committee and then eventually the NCOP recommends that the maximum period of imprisonment, or then with regard to a fine, should be reduced from 8 to 5 years. And then with regard to the remaining provisions of the bill, merely technical amendments, Mr. Chair, nothing really of a substantive nature. And then just the proposed amendment that the clerks of the court and the registrars of the High Court should also be required to provide information insofar as reporting on the implementation of the Act is concerned. So that brings us to the end of the proposed amendments to the bill itself. And with your permission, I would just maybe like to highlight then the report of the National Council of Provinces. If you will allow me a minute, I'm just going to switch to that document. Mr. Chair, this is then from page 14 onwards with regard to the report from the NCOP, or the report by the Select Committee as approved by the NCOP, and the proposed amendments are then reflected in their report. And it's, strictly speaking, within the bigger scheme of things, not many, but those are then the amendments as proposed by the NCOP in the report itself. I don't know whether you would like me to highlight anything else again for you, but I think we've highlighted the important aspects for you. Once again, then just to highlight clause 6, the penalties. The proposed amendment is reducing the 8 years maximum to 5 years. Thank you, Chair.
Thank you. Members, since this is a Section 75 bill, we can either accept or reject the proposals from the NCOP.
Chair.
Deputy Minister. Or maybe let me start with you, Honorable Ngod, and then the Deputy Minister.
No, Chair, I heard Mr. Dupree speaking about a proposed amendment where we must remove the definition of the court. I'm not sure if I got that clearly, and if the answer is on the affirmative, what are the reasons for the removal of that definition?
Mr. Dupree.
Thank you, Chair. Yes, that was a recommendation that came from the National Prosecuting Authority, because they expressed their concern, Mr. Chair, that you might have what one could possibly call a petty crime. And I don't want to use examples, but crimes which are usually prosecuted in the district court, but they may now qualify as hate crimes. But to require that all alleged hate crimes must be prosecuted then in your regional court at least, or then the High Court, which will not necessarily ever be the case, might overburden the court roles of our regional courts. And that is why the recommendation was made that it might be more appropriate to leave those, I don't like these terms, but the lesser serious offences within the jurisdiction of the district court. But that is what the result will be of removing the definition of court, Chair.
Thank you. Are you clarified, Honorable Mola?
Yes,
Chair,
yes.
I was also going to just add on Honorable Mola's question. The definition was there the only reason for the definition being there was to make all cases go to the regional court. The NPA, and we'd wanted that because of the seriousness of the cases, the fact that it's new law, etc. The NPA had raised concern that it's the regional courts. We don't know how many new cases there are going to be. I personally don't think it's going to be that many. But the NPA had raised concerns that the regional courts are where the court backlogs are. And therefore, they had asked that we not restrict it just to the regional court and above. And we'd agreed with that as the department, because yes, there are problems in the regional courts with backlogs, and we don't want to inadvertently add to them. It is the NPA who decide which court, whether a matter is going to the district court or the regional court. That's with them. But Chair, then while I'm on the floor, so I just wanted to add that to Mr. du Preez's explanation. While I'm on the floor, just to say that in terms of the support in the NCOP, it was a Section 75, so a party vote, not a provincial vote. And the DA and the Freedom Front Plus opposed the bill as they did in the National Assembly. I'm not sure about the ACDP because people just call out their names, they don't call out their parties. But the EFF supported the bill as they had supported it in the National Assembly. In fact, on the reduction of the maximum sentence from 8 years to 5 years, it was Honourable Motsumai from the EFF that had seconded that proposal. So it largely, basically, the support largely seems to be the same as what was in the National Assembly. Obviously, some of the parties in the NA are not in the NCOP. One interesting point, just lastly, was that in the public submissions, there were a number of positive suggestions from the Western Cape government, which were accepted. I'm not sort of particularly sure how the Western Cape government, which is under DA control, was supporting the bill, but the DA is not. But anyway, that's a side issue. Thanks, Chair.
Minister, you are starting to be provocative, and it might divert us.
I'm sure Honourable Breitenbach won't be provoked, Chair. She's too mature for that.
No, let's just focus on the text so that we can finish. Let's just focus on the report. Are you done?
Yeah, because the risk is that if Honorable Breitenbach reacts to the comments, she stands a risk of being seen as immature. So it's best that...
Are you done, Deputy Minister?
I'm done, Chair.
Thank you. Honorable Horn?
Yeah, Chair, let me firstly say I'm definitely not provoked. I will remind the Deputy Minister and the rest of the committee. However, that in this committee, the DA also came with a whole raft of positive suggestions, which for political reasons, the majority decided not to accept. So it's good to hear that when the DA comes with proposals in the form of, let's say, the government, where we are in government, then at least the ANC is able to bridge that political divide and listen to it with attention and appreciation. Thanks.
Thank you. Let's proceed. Are you done, Mr. Dupree?
Thank you, Chair. I think from my side, yes. Thank you very much. And maybe just to thank Ms. Botha also for assisting me through the whole process as a team member. Thank you, Chair.
Yeah, thank you very much. Members, how should we proceed? Must I table the whole bill as amended by the NCOP? But we will deal with the report on Friday. Do we support the proposals raised by the NCOP, or is there any particular one that we do not support? Because we can either support or not support, but we cannot change them. We cannot change them. So where we do not support, it reverts back to the bill as it was passed by the NA. Members, do we support the amendments as proposed by the National Council of Provinces? Honorable Mola?
Thanks, Chair. I propose that we support the amendments as proposed by the NCOP. Thank you.
Thank you very much. Any seconder?
Honorable Neo Druchen. Honorable Neo Druchen seconds, Chair.
Honorable Neo Druchen seconds. Any Honorable Hon?
Yeah, please note that we reserve our position, Chair.
The Democratic Alliance reserve its position. Any other party that wants to reserve its position?
EFF will have to, go through the whole comments and the bill before, but that's all, Chair.
Okay. Okay, we agree with the bill. We note the reservations of the DA and the EFF. On Friday, we will adopt the report. Thank you very much. Maybe it might be the last time we interact. Maybe on Friday we interact with the unit, the legislative and drafting unit. Would like to thank you very much, Ms. Pillay. Please communicate our appreciation to your team. We know that you have been working under very difficult conditions, but you continued to give quality support to the committee. We are really appreciative of every one of you who has assisted us with all the bills that we have processed. Quite a number of them. We are really appreciative of that. Please pass our gratitude to them, to all of you. I see there are hands here. Honorable Ngola, Honorable Deputy Minister.
No, it's an old hand, sorry.
Okay, all hands, Deputy Minister.
No, Chair, this is your last bill, unless any of the other bills get returned from the NCOP, although the Correctional Services Amendment Bill and the Judicial Matters Amendment Bill won't be returned. They're not amending it. But if in case this is the last time you're dealing with legislation, to thank the committee. I mean, it's been a very heavy legislative workload. But the committee has worked hard, and to thank them for the work that they've done on the bills that we brought. Maybe just to say, if you are feeling a bit empty, not having any more bills, There are other bills we can introduce. There's such a big legislative workload, but we're happy to bring more bills if you're worried your life won't be what it was before. Thanks, Chair.
No, thank you very much, DM. Would also like to thank you. We have really been very helpful. We are really happy to have worked with you during this term. You have made our work easier. We'd like to thank you very much. To you and your team, we are very grateful. Thank you very much.
Hopefully, Chair, that the cabinet with the DM have learned to do things expeditiously as cabinet, so that we don't get into these late hospital passes. I hope they've learned those lessons.
It's an important...
Specifically, as they now started listening to the Western Cape government, they are very speedy, so they can...
Please, please, man.
Can I say that the Western Cape government specifically said they support the bill, which is not what the DA has said. So that's that you may need to look at. Also with Ms. Mqebane, EFF supported the bill in the NCOP, so I hope that Honourable Motsumai won't get into trouble and your EFF members in the NCOP. Thanks, Chair.
That's
nice. No, thank you very much, members. But I think the point raised by Honourable Janji is something that needs to be worked on seriously. It's just unsustainable that we can continue to work the way we were working in these 5 years. Firstly, it makes us to be in conflict with our courts, which is not the right thing to do. I think we need to plan better. The department, you need to focus more on recruiting. This continuous understaffing of that unit is a serious problem. Because it has got a direct bearing on the mandate of Parliament, which is legislative making. So it will be important that you don't wake up when people are left with 2 years to retire to see that you are now in a crisis mode. I think it's important that for this unit you must have medium to long-term planning. Introduce people on time as part of your succession planning, but also allow a situation where members in that unit have a manageable load. It was not good generally to see members of that unit, Mr. Dupree's and others, having to balance the workload and also their health issues. So we think that it needs really to be looked at. But even under those circumstances, the members of the unit continue to give us quality support. We are very appreciative. Members, if Honourable DM, you are excused before you fight with Honourable Horn.
Thanks very much, Chair. Goodbye, everybody. Goodbye, Glenys.
Yeah, at least he's living with his tails between the legs after that last input.
Goodbye.
Sorry, Honourable Janki, whose side are you on?
Side of the truth. Members, I think you would have received by now an email of the screening results for the interviews that we had. 2 issues, 2 candidates have got issues. We have already written to them that they need to respond to the issues raised by Monday, 4:30, so that we can, as a committee, decide whether we are satisfied with the responses that they would have given us and whether we would need to engage them further. So it will assist us to plan, because it would be important that before the 6th, this issue of the Human Rights Commission must serve before the House. That is one issue. The second one, there is this bill, the state liability bill. We took a decision long time ago that we need to deal with that bill. In fact, the department needs to introduce a comprehensive bill on the issue of state liability, which they could not, because there seems to be a disagreement between themselves and the Department of Health. It is reflecting badly on our program, that there is a bill that we have not processed for the past 5 or 7 years. So what we are proposing is that we write a report to the House that the bill is going to be withdrawn. So the Secretariat and the Research Unit would look at those technicalities, so that before the 6th, a report needs to go to the House that we thought that the executive will withdraw the bill. They are not withdrawing the bill. So it's important that we must take action because it reflects bad on us as the committee, despite the work we have done. I think that is one issue. So members, I'm just going to put issues so that members can comment on them once. And then on the 29th, we were just planning that after the last day, that is on the 29th, after we have met with the legal profession, we can have our own small lunch as the committee and to bid farewell to one another for the work we have done together. But we can say all of that in that lunch. But there are still other things that are coming that we still need to deal with. For instance, it will be the issue of the South African Human Rights Commission. Is going to be the issues that we still need to ensure that we get them through the program and before the end of the year, that they serve before the House. That's that on my side. And then next week, I think if the research unit can prepare a report, we need a report that we need to adopt for the recommendations we have made on Judge Mutata and Judge Slope. Sometime next week, we will need to vote on the report before it goes to the House. Those are my issues that I wanted to raise. Any comments? Honorable Horn?
Yeah, thank you, Chair. No, thank you for that. Those proposals, I think we're in broad agreement with it. Will you please just note that on the 29th, unfortunately, in my constituency, there is a by-election of a very marginal DA ward, which the evil ANC wants to snatch off the DA. So I won't be able to join you at that specific lunch. I will be there to try and protect the ward. Thank you.
If I were you, I would stay here because we're taking it. But
Yeah. The fact that he's shaking already, it means that we are making a serious effort there and a serious impact.
In your dreams.
Honorable Nivot Drugan?
Thank you, Chairperson. Thank you for all the issues that you've raised. I've taken note of it. Just wanted to clarify when the legacy report, when do we as a committee adopt the legacy report, or is that held until next year sometime?
No, thank you very much. No, I think it's around the 1st. Committee Secretary, can you confirm? But
Please underpin the interpreter, Honorable Drugan.
No, we will need to adopt the legacy report before we leave, before the 6th. I thought it is the 1st, but they will check and then they will communicate with all the members.
Okay, thanks, Chair.
Thank you very much. That brings us to the end of the meeting. The meeting is adjourned. Thank you.
Bye-bye.
Bye-bye.
Thanks, Chair.
Thank you.
Recording stopped.